Your worship, we're ready.
Okay. I'd like to welcome everyone to the special meeting Tuesday, November 22nd at 4 p.m. First on our agenda is disclosure of pecuniary interest. Does anybody have a pecuniary interest? Seeing none, we will move on. Tonight, our speaker, we have a presentation from Harold G. Elston, Integrity Commissioner for the Township of Nipissing. And this is council orientation training. And we're YouTubing this, taping it. And if anybody's there, we welcome you to enjoy or work with us as we get some training from the Integrity Commission. So, Mr. Elston, can you hear me?
I can, yes, Your Worship. Thank you.
Well, thank you for being here tonight. And Chris has given us a handout that I think you forwarded. And otherwise, the floor is yours, sir.
Well, thank you, Your Worship, and good afternoon, members of council. Good to see everybody. It was about a year ago when I was before the last council. So for some of you, this will be a bit of a repeat. I've sort of expanded it a little bit. But I find the best way is if you have any questions, just as we're sort of moving through this, any questions, or if you'd like me to expand on anything, I'm happy to do that. And I think there is maybe a closed part of this. So if you have any questions that you just like to ask me in the closed session, please just feel free to do that. So I have slides, and if you see me looking up, it's just because I have another screen in front of me here with the PowerPoint there. So I'll just, if I can figure out, I'll just work my way through it. So you'll see I've listed the topics there. There's sort of 8 broad areas that I'll talk about. A bit of an overview, just I think it's always helpful for council to understand how municipal government works from a sort of a bird's eye view. Bit of a discussion, mostly taken right from the Municipal Act, about everybody's roles and responsibilities. A bit of a slide on council staff relations, which is a big part of the governance model. I talk about municipal accountability officers. So as your integrity commissioner, I'm sort of lumped in this category of accountability officers, and there's a few others that some places do appoint. A little bit about codes of conduct. Just one slide about MFIPA, the Municipal Freedom of Information and Protection of Privacy Act. Just you on a sort of daily basis don't really have to deal with that act, but it's always good to know, what part of your correspondence and record is accessible by the public. I have just a couple of slides on meetings, open and closed. And then a few slides on the Municipal Conflict of Interest Act. It's, I think, one of the most important things that I can do to help you folks is to answer questions or help you know whether you've got a conflict under the Act. Anyways, so the overview. Really, you've probably heard the expression that municipal councils are creatures of statute, or municipal governments are creatures of statute. So all of the powers that you have, the obligations, duties, they all flow from one of several provincial laws. So of course, the Municipal Act is the main one. The Freedom of Information and Protection of Privacy Act, the Municipal Elections Act, and of course the Conflict of Interest Act. And so it's just good to bear in mind that, you know, there are very, you know, sort of, I guess, strict controls and over your power and authority. And, you know, we see them changing. If you've been keeping an eye on what's coming out of Queen's Park, a lot of changes. And some of them have some people worried. There's some fundamental things that seem to be in flux a bit. So that's, you know, sort of your master, if I can put it that way, is at Queen's Park, and the rules can change. The second bullet point I've got, I just tried to take all the different concepts and legislation and roll it into one sentence. So I think it's fair to say that councils are to govern as a whole in a transparent and accountable way, free from conflicts and bias, in a respectful and honest manner. So we'll work through each of those particular phrases or requirements as I go through the slides. All the things, all the rules that are in place, whether it's code of conduct or under the Municipal Act, in my sense, any of it anyway, is that it's really all about maintaining the public trust in your decisions and your governing. So, you know, in a very sort of simple and straightforward way, the folks of Nipissing have their lives, their businesses, but someone needs to be sort of running the town, the township. And so they've, you know, through the election, have selected you folks, and they have given you their trust to make some very important decisions on their behalf. Everything from planning decisions to kind of services that you provide, and the like. So maintaining their trust is important, and I think is what all these various rules at the end of the day come down to, making sure people know that, you know, their community is in good hands, and they can trust you folks to make good decisions. I'll talk about the role of council and the mayor and staff just in the next few slides. And these are all taken right from the Municipal Act. So it's, you know, I've pretty much just copied them from the Act. They're very explicit as to everybody's role. So to start with your role as council, and this is you folks as a group, it's to represent the public and to consider the well-being and interests of the municipality, to develop and evaluate the policies and programs of the municipality, to determine which services the municipality provides, and then to ensure that there are policies and practices and resources, you know, at the you know, disposal of your staff to make sure that your decisions can be implemented. It's also your role to ensure the accountability and transparency of the operations of the municipality, to maintain the financial integrity of the municipality, and to carry out duties under the Act or any other act. So there are, you'll see obligations that fall on you under a number of different statutes. So, and this again is council as a whole. You operate as a group, and this is what you're responsible for. The Municipal Act separates out the mayor or head of council and assigns specific responsibilities. So the first one is to be the chief executive officer of the municipality. And then below that, you'll see I've just jumped ahead to the next section that actually says, what is the chief executive officer? What's that involve? So it's to uphold and promote the purposes of the municipality, to promote public involvement in the municipality's activities, to act as the representative of the municipality and promote it locally, nationally, and internationally, and to participate in and foster activities that enhance the economic, social, and environmental well-being of the municipality and its residents. So the mayor is the sort of first officer and is responsible for promoting the municipality at all levels and leading you folks and the municipality. The second role of the mayor is to preside over council meetings so that its business can be carried out efficiently and effectively. So this is a very important role, and I know just from being around for municipal councils for 35 years or so that things can get bogged down, things can get passionate, and it's always good to remember that you do have to work through things, you have to be efficient, you have to be effective, and that falls on his worship to be able to just direct you in that way. The mayor is to provide leadership and represent the municipality at official functions. And the last one here is to provide information recommendations to you folks with respect to the role of council, respecting accountability and transparency and all the policies and procedures of the township. So this is something that I have started to use a bit. As you know, one of the roles of the Integrity Commissioner is to provide advice. And so I've, over the last few years had discussions with various leaders of council, members or mayors. And if the mayor is sort of, anxious to get across some policy initiative or to remind council of certain things, by working with the Integrity Commissioner in his role as the person responsible to provide recommendations to you on transparent government accountability, this is one of the powers, so that the mayor can, have a discussion with me and say there's a need to sort of highlight something or remind people of something, or just to provide some direction to council on all kinds of different things. So it's a pretty effective role, an important one, sort of to be the conduit to me or for other resources. The role of your chief administrative officer is really just exercising general control and management over the municipality, and then performing such other duties. And so I know Chris is busy for you folks on all kinds of things. In a larger municipality, you'll have a staff of perhaps hundreds of people, but it's said that the chief administrative officer is really the only employee. So when you're dealing with staff, it really needs to go through your CAO. The clerk, again, this is right out of the act, and I think it kind of understates how important the clerk's role is. I think just the way things tend to go, the clerk is the sort of a custodian of all the things municipal. They know where things are, they know how things are done, they know who to talk to about certain things, and just a great resource. And I'm sure that you folks have great confidence that you can go to Chris and get what you need to know. help you through things. So the role of staff, and I'll just at this point reflect back on the role of council. So if one of the roles of council is to establish the goals and objectives of the municipality, to decide which services you're going to enter or you're going to provide, it's the role of staff to implement those decisions. So they're there to, sort of hear you and understand what it is you'd like to achieve, and then they go and spend their days implementing those decisions. They will do research for you, provide you advice, provide recommendations. But at the end of the day, you folks are the ones who are sort of setting the agenda, and staff help you to get there. So interestingly, the Municipal Act does not provide any duties to individual members of council. There's no section of the act that says it's the role of a councillor. And so, that is because they've said that council operates as a whole. You make decisions as a group and not individually. Now, there is the ministry has a guide for councillors, and it says that you're a representative, which of course is pretty clear. You're a policy maker as part of the bigger group, and a steward of all the municipality's resources, again, as part of the group. So it said that councillors are public officials with no management powers. And I know in smaller municipalities, sometimes there is, a little bit of a crossover there, so that councillors will, work with staff, and which I think is fine, as long as everybody is sort of respectful of each other's roles, and treats each other properly, and understands, people's different responsibilities. So, but interestingly, no specific role for individual councillors. Council and staff relations. This is mandated by the province, that you actually have a specific policy dealing with council staff relations. It's also part of most codes of conduct, and as I'll explain a little bit later, it's often the source of complaints when council staff relations sort of go sideways a bit. So the policy just sets out what you would expect, that people need to be respectful of each other. There needs to be an acknowledgement of staff's expertise and background, and always to be courteous and respectful. And, again, that goes to the public confidence. The public, may be watching, and they need to see that you folks, the two levels of government, so to speak, are working together. Just a note here, the whole sort of integrity commissioner code of conduct and what we call accountability officers is a relatively new addition to the Municipal Act and municipal government. So a number of years ago, if you go way back, any power that you had as a municipal government had to be identified specifically in the Municipal Act. So the Municipal Act was much longer, hard to believe, than it is now, but much longer, and a lot of very detailed sections assigning different powers. And I think it was 15 or 20 years ago, the province decided that was a bit restrictive, and that an amendment was needed to grant municipal councils a little more discretion, a little more flexibility, a little more authority. And so they amended the Municipal Act to give you the powers of a natural person. So some just sort of broad powers. You didn't need to comb through the Municipal Act to find the power to enter a contract about something. You were given those powers. But at the same time, I think they thought, well, if we're gonna, sort of loosen the reins a bit, we need to introduce some checks and balances. So that's where these accountability officers come in. So there are integrity commissioners, there are lobbyist registrars, there are municipal ombudsmen, there's auditor generals. All of these can be appointed by a municipal government. And also I left off this list closed meeting investigators. So, on the one hand, the province gave you a little more power, made it less specific, but introduced some sort of checks, balances. I don't like the word watchdogs, but people that are there just to make sure the public trust is maintained. So I think that's all I had on that. Codes of conduct are now mandatory. So every municipality, I think 444 municipalities, have to have a code of conduct, and they have to have an integrity commissioner or access to an integrity commissioner. And this started, back in I forget the year of the Bellamy Commission, but in the early 2000s, you probably won't remember or I didn't find it such an earth-shattering event, but back then the city of Toronto was deciding to purchase new computers for the whole city. And as you can imagine, that was an expensive and difficult, complicated process they went through, and there were a lot of irregularities in the procurement process and a lot of suggestions of improprieties. And so there was a public inquiry, and Justice Denise Bellamy conducted a long inquiry and heard all kinds of evidence, testimony from all kinds of experts and people who were there. And so at the end of it, she came out with a series of recommendations, but one of them was that the city of Toronto had to have an integrity commissioner, and that other municipalities could have an integrity commissioner. So that's how the concept was introduced to address the problems from the city of Toronto trying to buy some computers. And so in 2019, almost 3 years ago, the province passed Bill 68, which made it mandatory for everybody to have a code of conduct and an integrity commissioner. So it's sort of grown from there. I was first appointed in the township of Georgian Bay about 10 years ago, 12 years ago. And so it's been, sort of building up. It's taken a while for the integrity commissioners to, sort of come up with some accepted and standard ways of doing what we do. But there's just a very talented and dedicated group of integrity commissioners across Ontario. Some are at big firms, some are small town lawyers like me. Most are trained as lawyers, but not all. And, it's become a big part of municipal government. So one of the things that I think is still evolving is the code of conduct. The province has passed a regulation sort of mandating what should go in a code of conduct. And so the province has said there has to be policies in 4 areas. So there has to be a policy dealing with gifts, benefits, and hospitality. There has to be a policy dealing with respectful conduct, including conduct towards officers and employees. There has to be provisions to deal with confidential information, And there has to be a use of policies talking about the use of property of the municipality. But they haven't come out with sort of a standard code of conduct. I think a lot of us were hoping they would develop one code that would apply across the province in every municipality. And, you know, for those of us who are the integrity commissioner in a couple of places, it would be easier to not have to have a different code of conduct in each municipality, but we're not quite there yet. But I think there is still hope that at some point there'll be kind of a universal code, and it'll encompass these things, but they include much else than this too. One of the things that it's important to remember about codes of conduct, a couple of things, I guess. First of all, it can't create an offense. So a code cannot say that it's an offense and you can be prosecuted under the Provincial Offences Act for breach of the code of conduct. It just, it doesn't sort of rise to that level of law. And it also restricts the kind of penalties that can be imposed. So I go through how a complaint works a little later on, but the Act says, first of all, that all I do if I investigate a complaint, I make a recommendation to council. And if I find that the member of council has breached the code of conduct, I can recommend one of two things, either a reprimand or that the councillor's pay be suspended for up to 90 days. And under the Act, those are the only two penalties. And I just recommend them to council. So it's up to council to take my report, hear from me, and decide whether or not to go along with my recommendation. And it's all done in open session, which for those of us who are sort of used to, you know, municipal law and closed sessions, it sort of seems to go counter, because of course, one of the reasons why you go into closed session is to deal with personal matters about somebody. But I guess the thinking is if you are an elected official and you are found to have breached the code of conduct, that's something that the public should hear about and needs to know. So when there's a complaint, and if I decide that there has been a breach of the code, I deliver my report in open session. And that's where part of the report is I make one of these two recommendations. And then it's over to council to decide. A couple of bullet points just about the integrity commissioner. I think the first one is maybe the most important, that we are independent. So we're not a member of staff, we're not your agent, not a consultant. We are appointed under the Municipal Act by bylaw. So we're a statutorily appointed official and quite independent, which, you know, makes sense. If it's my job to either give you advice about things or to look into allegations of breach of the code of conduct, everybody needs to know that I'm independent. The next bullet point there deals with the inquiries being confidential. And this is important. So the Municipal Act actually says that the information that comes to my attention is to be kept secret. I am to preserve confidentiality over it, keep it secret, and I only reveal as much as I have to. So if I get a complaint and I do an investigation, things that people tell me are I keep in confidence. I'm allowed to sort of generalize about the evidence that I found. I don't need to be completely detailed and specific in order to preserve this confidence. But at the same time, I'm allowed to sort of reveal information if I think it's necessary so that people will understand what happened or how I came to my decision. So it's always one of the toughest things that I have to grapple with if I do get a complaint and am doing an investigation is how much do I reveal and how much do I, keep confidential. I report to council in open session, as I've just mentioned. I apply the code of conduct and I say other ethical rules. So, for example, your procedural bylaw will have some rules dealing with conduct. And so I'm authorized to apply those rules, council staff relations policy, those kind of things. A new one back to March of 2019, when all this became mandatory. Oh no, I guess it was about the same time. We have been given the responsibility to apply the Municipal Conflict of Interest Act. So it used to be that the Integrity Commissioner would just deal with code of conduct matters. And if there was a concern that a member of council had a pecuniary conflict, so a financial conflict, it had to go to court, had to be an application to a judge. But they have decided over the last couple of years at some point to download the authority and the responsibility for applying the Conflict of Interest Act to integrity commissioners, at least sort of at the first instance. In a little bit, I'll get into more detail about that, but it is still possible for someone to go to a judge. It's possible for me to do an investigation and then think, I think this should go to a judge, and I'll explain the sort of circumstances and why that might be necessary. Provide advice on code and MCIA matters to members. So this is where I think I'm sometimes of the most use to counselors. If you see something on an agenda and you wonder, might I have a conflict here? And some of them are obviously direct. You own the land that's subject of the rezoning, or your wife owns the land, your husband owns the land, those kind of things, where it's pretty easy to know that you have a pecuniary interest. But the act is, kind of nuanced, and there are times where I think it's a good idea to get in touch with me, and part of my job is to give you advice on conflict. So again, a little later on, I talk in more detail how you go about doing it and what are the rules around that. But I think it's a good service to provide. It's what I enjoy. As I say, working one-on-one with counselors, being able to help you sort through the Conflict of Interest Act and your various business or personal relations, and whether or not you can participate in a vote on something. Provide education to members, such as I'm doing this evening, to council, to staff, and to a lesser extent to members of the public. I'm available to help just in a very basic way with some advice, but I tend not to get too many requests from members of the public for sort of an education about it, but it's there. In terms of advice, there's a couple of kind of ground rules here. The first is that your request for advice must be in writing. Now, what I usually say is I think it's a good idea to call me ahead of time or email me, and we'll set up a time to talk. And we can just talk through what it is, what the circumstances are, what your business relationship is, what's the matter before council. And it just sort of helps me understand the context and maybe help you craft the advice so that we can agree on what exactly is the question, what exactly do you need advice on. So once we do that, then, and email is fine. So you send me an email just saying, I'm the owner of this business. There's a property next door. There's a rezoning. Do I have a conflict of interest kind of thing? I have to give my advice to you in writing. And, I think there's a couple of reasons for that. First of all, so you'll have something concrete and there won't be any doubt about, what you asked me or what I told you. But as you'll see later on, if somebody complains and says, well, you had a conflict, it's very good if you're able to say, well, I have a letter from our integrity commissioner and he told me that I didn't have a conflict and that I was okay to participate in the discussion and vote on the matter at council. So it's good that you have it in writing, and it's good to hold on to it. In terms of the advice I give, I'm used to working as a lawyer and the solicitor client privileged sort of principles, so that if you tell me something or I tell you something, it's strictly confidential and I can't divulge it. As an integrity commissioner, it's not quite that strict. So generally speaking, if I give you advice, I have to keep that confidential. So I don't tell people what I told you, unless you, first of all, tell me it's okay, Harold, release the letter, and I'm happy for you to talk to someone and explain it. But the second time when I can reveal it is if the counselor were to release, say, only part of my advice, and I don't think that part gives an accurate view of the advice I gave, then I'm able to release all the advice. So the example I always give is if you asked me whether you had a conflict and I wrote a 2-page letter that at some point in the letter I say, well, it's arguable that you don't have a conflict, but then I continue on to say, but I think all things considered, in the circumstances, you do have a conflict. If I read in the local newspaper the next day, integrity commissioner says it's arguable counselor doesn't have a conflict without the rest of it, then I'm at liberty to release the full advice. So I can say that's never happened, but it's sort of an example of how I am able to release just if I think the record needs to be corrected a bit. So that's advice. Talked a bit about, the confidential nature of it. So the act actually says that the commissioner shall preserve secrecy with respect to all matters that come to his or her knowledge. The duty of confidentiality prevails over the Municipal Freedom of Information and Protection of Privacy Act. So it sometimes happens, I get a complaint, I write a report, member of the public wants to look at my notes, see what my draft report said, so they make a request under MFIPA. But it's very clear that they are not entitled to my notes or my file, which makes sense. I need to be able to take notes, have a complete and accurate record, and I choose how much of that gets disclosed. The third bullet point: I'm not a competent or compellable witness in a civil proceeding. So this has never really come up, but if for example, there was a conflict of interest issue and you sought some advice from me and I gave you my opinion as to whether or not you had a conflict. And then because of that conflict, someone is suing you and they try and call me as a witness to see what we talked about, what advice I gave you. And so I can't be compelled to give evidence. I'm not a competent witness, as we say. So it's a bit like your spouse can't be called to testify against you. I can't be called. There are some instances, though, where all that kind of goes by the boards. For example, if I think somebody makes a complaint to me and I start an investigation and I think this is starting to look like there may be a criminal component to this or some kind of a criminal activity, then I put my pen down, I turn it over to the RC or the OPP, and they do an investigation, in which case they can see my work. And it's never happened, but a lot of the confidential nature that protects a lot of the information, I think, would be waived. Criminal matters, of course, just a whole new level of investigation. So, but for the most part, it's supposed to be confidential. I put together this list of the sort of common complaints that I get, just to give you sort of a sense of, when my phone rings or my email starts to kick in. So one of the first common complaints is to deal with conflicts of interest. And so remember, there's the pecuniary or financial conflict of interest, which is governed by the Municipal Conflict of Interest Act. And then there are personal or private conflicts of interest. And so your code of conduct will deal with those. So that's the kind of thing, your best friend has a matter before council trying to raise some money for something. Do you have, a personal conflict there? And those are sometimes harder to sort out, but it's something that comes to my attention. Discreditable conduct. So again, you can imagine any kind of intimidating, abusive, bullying behavior. I do get complaints about that. Conduct at council meetings. So where there's just a lack of decorum or, sort of the discussion becomes a bit disrespectful, a little too passionate. I get complaints. Conduct respecting municipal employees. In some places, this is a real issue, and I don't know why some places are worse than others, but it's a source of complaints where councillors sort of overstep, I guess, their role, and employees feel intimidated and bullied, etc. Improper use of office, improper use of influence of office. So, you always have to remember, because you're a member of council, you have a standing, a status in the community, and people look up to you. People take what you say, maybe and attach a little more weight to it than other people. So you just always have to be careful not to unduly use the influence of your office. Of course, that's why you're there, and you can use it for the betterment of the municipality as a whole and achieving goals of the municipality. But you just have to be aware that people are going to, be concerned that there may be some kind of an undue influence of that office. And last one is disclosure of confidential information. So there's always a concern that somebody has leaked some information or inadvertently let something slip. So always good to be, very careful, closed session materials, but, also other things that come to your attention, just because you're a counselor, you may be in someone's office and see something and just be privy to information that, most residents wouldn't be. So you just always have to be mindful of the obligation to keep these things confidential. Just a little bit about how a code of conduct inquiry goes. So people see something, hear about something, and so they make a complaint to me about it. So the complaint has to be in writing. It has to be signed in some place, and I just can't remember whether you folks require a sworn affidavit or not, but a very formal complaint process. And then it has to describe in some detail what happened and what sections of the code the person is alleging were breached. So when I get that, the first thing I do is just review it to make sure that it's within my jurisdiction. So there's lots of things that I can't help with, that I don't have the authority to deal with. And so I, usually quite quickly can tell whether this is something for me or not. And if it's not, I let people know that, that I just don't have jurisdiction over a zoning bylaw, for example, and there are other ways for them to, sort of pursue it. But once I, decide that it's properly before me, then I let the member of council know. So I usually, will send an email or sometimes call ahead of time and say, I have a complaint here. Here's what it's about. Here's what they say. And I'm very interested to hear your side of the story, because I've been doing this long enough and been a lawyer long enough that I know there's always two sides to a story. So I am always very anxious to hear what the member of council has to say. And so I say, I'd like to hear from you in 2 weeks. If you need a bit more time, let me know. And I find, almost without fail, counselors get back to me straight away. Because it's an important thing and people's reputations are at stake. So I hear back quickly. I always say, who would you like me to talk to? Are there any witnesses or people who can help me understand the background to this? And so I get, sometimes a long list of people to talk to. And once I get that, I go back to the complainant and I generally, I usually generalize it and I say, okay, well, here's what the member of council says. And what do you say to that? And so then I get something back, and then I undertake my investigation, which is talking to people, interviewing people, including the counselor, sometimes a couple of times. So it kind of evolves. I'll talk to someone and they'll mention something that, I didn't know about, and I go back to people and say, now I understand this is what happened. And so, you can imagine it's a bit of a process. It's an investigation. And when I feel that I've fully understood, what happened and the background, then I write a report. And this is the hard part, because I'm sort of the prosecutor, I'm the defense lawyer, I'm the jury, the judge, and I sort of have a number of roles. I have to make sure that I've got the evidence straight, that I'm being fair, that I'm being reasonable, that I'm properly applying the code or the Conflict of Interest Act. And so I find this is the most difficult part of the job. And in that report, I make a point of being fair and making sure that if someone picks up the report and reads it, they'll understand what happened. They'll understand what the rule is in the code of conduct, but also why it's there, why it's important. And then I make my recommendation, which is the report is then sent off to you folks and delivered, as I say, in open session. And you folks take it and debate it and decide what you want to do. So I like to try and do it within 90 days, but sometimes it's just not possible. I have recently sort of retired as the integrity commissioner for a number of municipalities. I had too much on my plate, and I still have a reasonably busy municipal law practice. So I think I'm in a better position now to get advice to people, get reports done a lot quicker. But I was quite overloaded for a couple of years there. So, I've enjoyed working with you folks. You were a newer appointment for me, and so I'm happy to continue on with you folks. I think I scared Chris a little bit. She might have heard of my retirement. So, but I'm still here for you guys. I think I have just one slide on MFIPA, as we call it, because it's just too much of a mouthful to say the Municipal Freedom of Information and Protection of Privacy Act. There is a provincial one. There is the Freedom of Information and Protection of Privacy Act, which deals with provincial institutions, but you have your own act. Basically, the thrust of it all is that the public has a right of access to all the records of the municipality, except if that record falls under a series of exceptions. So, and I haven't put all the exceptions here, but there are some things that are just quite clear. If there is a record, so first of all, to be a record of the institution, it needs to be it can be a written document, it can be a video recording, any kind of record that's in the control and the custody of the municipality constitutes a record. So all the emails, so if you're using your municipal computer and sending out emails with your municipal email address, and they're kept in a email bank at the municipal offices, those are part of the municipal record, and they may be accessible depending on whether or not they meet one of the exceptions. So always good to remember when you're sending emails out that they can be, people can request to see them, and they may be disclosed, and you don't really get a say in the matter. So there are a bunch of exceptions. Most of them aren't as relevant to members of council. A lot of them have to do with sort of financial records of the municipality, proprietary information, technical things that the municipality has that shouldn't be disclosed because it might be harmful to the municipality. Things dealing with prosecutions while the prosecution is ongoing. MFIPA allows you not to disclose it, although there are disclosure rules in prosecutions as well. So it's kind of a parallel rule, but for our purposes, for MFIPA, a lot of things related to prosecutions. Things that are provided, either explicitly or implicitly as being confidential can be refused. The disclosure can be refused, but it's not good enough just to stamp confidential on something. It's you need more than that. So just good to remember that the act is there. I'm not sure how much of a burden it is on your staff. In some of my municipal clients, there is a huge workload. The Freedom of Information requests that come through the clerk's office, and the clerk is usually appointed as the head of the institution. It's just overwhelming. And they're subject to appeal, and there's strict time limits. And so the Information and Privacy Commissioner's office is well staffed. They've got many people, often lawyers, who are charged with adjudicating and looking into these appeals, and it gets very complicated and expensive and time consuming. And it's a real source. You may just know from reading the newspapers that there are, I think there's a, sort of a pretty good argument that in Canada, we're a little too restrictive. Our governments at all levels, it is hard to get information. And so I think there may be a bit of a reckoning in this regard. But for your purposes, just remember, and I think it's mostly the emails that you're sending around, always think, okay, somebody could request this may become public. Do I want that? Do I want to see this on the front page of the Globe and Mail kind of thing? So about meetings, I guess the starting point is, and this is all straight from the Municipal Act, all your meetings are to be open to the public. That's, as I say, the starting point. Meetings shall be open, and this goes to the fundamental principles of public trust. The problem with a closed meeting is people can't see what's going on, and people get concerned, maybe a bit suspicious. So, again, the starting point, meetings are open to the public, but then there are certain circumstances, and I've listed them here in all the small print. I tried to get it on one slide. There are circumstances where a meeting may be closed to the public. It doesn't have to be, but it may be. And so most of them are kind of obvious. So you can have a closed meeting dealing with the security of the property of the municipality. So, just as it sounds, whether it's about motion detector lights behind the arena, or, how you're going to secure access to a park, or, some kind of property of the municipality, you can talk about that in closed session, because it wouldn't really protect your property if everybody knew the code or whatever. So be personal matters about an identifiable individual. So the first thing is, a lot of people mix it up and read in here personnel matters. So it's not personnel matters, it's a personal matter, which might be a personnel matter, but it's a personal matter about somebody who can be identified. So those ones, for all kinds of reasons, make sense. You go into closed session for those. Acquisition or sale of property, like anything else, if you're buying and selling your land, you want to be able to discuss amongst yourself what your bottom line is, or how much you're prepared to pay. And that's because it's a municipal asset, and you're the sort of custodians, the trustees over it. And so your obligation to the residents of Nipissing is to, get the most value you can for the property, or not spend too much on it. So again, that's a kind of an easy one to figure out. Labor relations, employee negotiations. If you're negotiating with the fire department, you really have to do that amongst yourselves, not in public. litigation or potential litigation, including matters before administrative tribunals. So this is one that the courts have looked at. It's not enough to just say, boy, we've got a problem out on the highway and someone might sue us, so let's go into closed session and talk about it. The cases have really said that it's a little higher level than that, the threat, and you almost need to have a letter from a lawyer making demands on the municipality or suggesting that there'll be a lawsuit coming before the litigation discussion can really go into closed session. Advice that is subject to solicitor-client privilege, including communications necessary for that purpose. So where I'm the municipal solicitor, I will, the mayor or the CAO will often ask me to provide a legal opinion. So I write that, it's privileged. I go into closed session, we talk about it, and it stays in closed session. And that, again, just makes sense that, people shouldn't know what advice you're getting from your solicitor. But that said, it's not enough just to invite a lawyer to the closed session just so you can go into closed session. There has to be some kind of advice that's being provided. Then a few other things here: trade secrets, technical, commercial, financial. I won't take you through all those, but a long list of things. And there's some other criteria. So going back to the Municipal Freedom of Information and Protection of Privacy Act, if someone's made an FOI request and you need to talk about it, you can go into closed session and talk about that. And then training sessions like this, I think it's helpful that a lot of the education sessions or a large part of a session is open to the public, because it's good for people to understand the rules. But we can go into closed session if there are things that you have questions about or concerns that you don't want to share in public. So it's one of the exceptions. Just a few more of the basic rules from the Act that I'll just leave to you. Those are more for Chris to help you work through and make sure you go into close properly and come out of it properly, and what you do in there, meets the Act. So there are closed meeting investigators. So you can appoint someone. In some places where I'm the integrity commissioner, I'm appointed as the closed meeting investigator. I think that whether it's through AMO, they have appointed, I think it might be my friend John Mascaron at Aaron Burles to do the closed meeting investigations, or it's through the Ombudsman's office. So there's a number of different ways. And basically, if someone thinks that a municipality, a council went into closed session improperly, they can call for an investigation. And so the investigator will look at, what was the matter that went into closed session, and just, apply the Section 239(2) exceptions to see whether or not it qualifies there. And then make a report out to you folks. So a little bit more about that, the report and the recommendations. So the next few slides, I talk about the Municipal Conflict of Interest Act. I've been going for about an hour or so if you need a break, but I'm happy to continue on, Your Worship.
Could we just take a 5-minute break, whatever, stand up, have a drink, perhaps use the facilities if necessary, and then we'll be back. Thank you.
Thank you, sir. Thank you.
little hockey game, stay there for 3 periods, or I don't go home.
Yeah.
Right? Fall down and land on you. Welcome back.
Thank you.
We're at your disposal again, so please continue.
Thank you, Your Worship. And my dog thanks you because I was able to feed him. So,
Oh, good, good.
so the next few slides, and it's the last sort of section, is on the Municipal Conflict of Interest Act. So I'll work through these. So Section 5 of the Act is where the rule is established. And so it says, where a member, either on his or her own behalf, or while acting for, by, with, or through another, has any pecuniary interest, direct or indirect, in any matter, and is present at the meeting of the council or local board at which the matter is the subject of consideration, the member shall disclose the interest and the general nature thereof, shall not take part in the discussion of or vote on any question in respect of the matter, and shall not attempt in any way, whether before, during, or after the meeting, to influence the voting. So, seems like a very wordy way of saying it, but the main point is that it's only pecuniary interests. So the Municipal Conflict of Interest Act only deals with a financial interest in a matter. And even though it's called the Conflict of Interest Act, it's the harm they're protecting against is you folks having a pecuniary interest. It may not constitute a conflict of interest. So it's good to keep in mind that it's just the existence of a pecuniary interest that kind of takes you out of the discussion, that disqualifies you, whether or not it is a conflict or not. The pecuniary interest is where you're excluded. So the first thing is you have to disclose it. So you're familiar with that. It's at the start of every meeting. It was at the start of this meeting. And if you have to disclose the interest, the general nature thereof, and there's a form that you fill out. And that form is kept in a binder somewhere and is available to the public. So there is let's call it a permanent record of the interests that you've disclosed. Second rule, shall not take part in the discussion of or vote on any question in respect of the matter. So it's not just don't vote, it's not take part in the discussion. And I think you have to give that a pretty broad interpretation. So if you have a pecuniary interest, it's best to not sit at the council table. It's almost a good idea to leave the council chambers, even if it's open session. But certainly you don't take part in the discussion. Even if you're trying to be helpful, you're just trying to clear something up, you can't. Of course, you can't vote. And you can't try and influence the vote before, during, or after. So you can't call up someone on council and say, look, I got a conflict, but here's what's going on, and we really should go ahead with this. It's just too risky, and that's why I suggest that people leave the room even in open session, because who knows, you're gonna fix your hair or your glasses, and someone's gonna maybe assume the worst, that that's some kind of a signal you're sending to try and influence the vote. So better just to eliminate any possibility that anybody can suggest you're trying to send a signal. Just leave the room. And of course, if it's in Closed session, when you have a conflict, you do have to leave the session because nobody can, the public isn't watching, so you have to leave that room. 5.21, it was a relatively recent addition to the Act. And what it really gets at is there are some things, and even they're sort of increasing in number, decisions that are made by staff. So, for example, now you'll have an authorized person who is going to approve your site plans. And it won't be a council matter, but the rules still apply. So you shouldn't try and influence that person, shouldn't discuss it with them. You just have to stay away from the matter if the staff person is dealing with it. And these, of course, are only things where it's before council. You can have a pecuniary interest in all kinds of things in the municipality, and I expect most of you do. It's only a concern when you're about to make a decision as part of council on it. So the matter has to be on the floor of council, it has to be on the agenda. That's where your interest kicks in and you've got to take a step back. So there are two kinds of interests that are sort of defined in the Act. The Act doesn't say what is a direct pecuniary interest. I think that it's just obvious. You own the land, you own the business. It's a direct connection to you personally. But there's two other kinds of interests that the Act recognizes and that attach to you. So the first is an indirect pecuniary interest. So, and these, you'll see there's 4 points I've listed there. This is right out of the Act. So you have an indirect pecuniary interest if you're a shareholder, director, or senior officer of a corporation that does not offer its securities to the public. So a private company. So if you're the president of a company, if you're a shareholder of a company, if you're some kind of an officer or director of a private company, if that private company has a matter before council, then you have an indirect pecuniary interest and all the rules apply. You have to disclose it and you can't participate in the discussion, you can't vote, and you can't try and influence the vote. The second is if you have a controlling interest in or are a director or senior officer of a corporation that offers its securities to the public, so a public company. So if you're the president of CIBC and CIBC wants a rezoning to expand the bank or buy some land or build a branch, then you would have an indirect pecuniary interest there. The third one is the one that is sort of gives people the most difficulty just in making sure they understand it. The member is a member of a body that has a pecuniary interest in the matter. So there's no definition for what a body is. So what's the way it's all sort of developed, and what most integrity commissioners say is you have to give that a really broad, liberal, wide reading. So if you're a member of the Chamber of Commerce, you're a member of the Business Improvement Area, you're a member of the Lions Club, you name it, a senior citizens group. If you're a member of that body and that body is coming to council and has a pecuniary interest, so the Lions Club wants a donation from council to get ready for the Easter parade, then as a member of the Lions Club, you have an indirect pecuniary interest in that matter and you shouldn't be part of that discussion. And the last one is the member is a partner, business partner of a person, or is in the employment of a person that has a pecuniary interest in the matter. So if you work at the hardware store and the hardware store is coming for a rezoning, you have an indirect pecuniary interest, and you shouldn't be part of that discussion. So the next kind of interest is what they call a deemed pecuniary interest. So deeming, of course, is sort of a legal concept where somebody else's pecuniary interest is deemed to be your interest. And so the Act says the pecuniary interest, direct or indirect, of a parent, a spouse, or a child of the member is deemed to be the pecuniary interest of the member. So your husband or wife's indirect pecuniary interest is deemed to be your pecuniary interest. Your parents, your children. And there's a pretty broad definition of children. So stepchildren or anybody who you've sort of demonstrated an intent as a parent over, that's deemed to be your pecuniary interest, and you have to step aside. The omission from that list is your brothers and sisters. So siblings are not on the list. And it's a little bit shocking, but your brother or your sister could own the land and come before you to seek a rezoning, and strictly speaking, under the Municipal Conflict of Interest Act, you would be able to participate and vote on your sister's rezoning. So I would tell most people you shouldn't. I think that is a bit of a sort of gap in the legislation, and I think that'll change. We had a big inquiry here in Collingwood, and that was one of the recommendations, that siblings should be on that list of deemed interests. So those are all the different interests. And so the next, sort of important point to understand is that all of that being said, there are exceptions. So there are times when you can have a pecuniary interest, a direct one, an indirect one, a deemed one, but you can go ahead and vote. Section 5 doesn't apply. And I've just kind of paraphrased the key ones here. So I've just put 3 bullet points. This is all in Section 4 of the Act, and I probably should have given you an exact excerpt of Section 4, but these are the main ones here. So Section 5 doesn't apply to a pecuniary interest you have in respect of an allowance for attendance at meetings or any other allowance, honorarium, remuneration, salary, or benefit to which you are entitled. So you can vote on your honorariums, you can vote on your travel allowance, you can vote on whether or not you should be indemnified under your indemnification bylaw, all those things. It's fair game, you can participate. The next big one, and this is sort of the one that I find I do a lot of work with counselors on, by reason of the member having a pecuniary interest, which is an interest in common with electors generally. So if, and it can be all the electors in the township, or it can be only part of the electors, some subset of electors. So, and it's hard to tell. So an example that comes up, and you may, this may be familiar to you folks. So if the township, if you have a bunch of roads that are seasonally maintained, and somebody brings a motion to say, I think we should maintain our seasonal roads full time. And you're a counselor and you live on a road that is now seasonally maintained. So do you have a conflict, or is your interest the same as electors generally? So what I say is, if there's 100 people that live on your road, then your interest is the same as them, and you should be able to vote on that. If there's only 2 people on your road, maybe you shouldn't. Maybe your interest is quite different from a lot of people in the municipality, and so it's often it's sort of a question of the numbers, how many people live on that road, how many people live in that community, how much a part of a group that all share this same interest are you, or how different is your interest. So, but it's the one that comes up a lot, and some interesting discussions about it. And the last one that comes up a lot is by reason of an interest which is so remote or insignificant in its nature that it cannot reasonably be regarded as likely to influence the member. So it's not just one that's remote or insignificant or small. It's one that is so small that nobody would think you would be influenced by that interest. So I had an example of one over in Bruce County, where the member of council was a dairy farmer, and there was a local processing facility that needed to be expanded. And so council was trying to decide whether they would fund, I can't remember, all or part of the expansion of this milk processing plant. And the member of council, who was the dairy farmer, it was a co-op operation, and his family had, I think, 1 share in the co-op. And so he had kind of 1/4 of 1 share in a co-op. And so he and I talked about it. I don't think he at the end of the day agreed with me, but I said, I get it. That's it's 1 part or a share of a whole bunch of shares. But for a member of the public, they might look back and say, I know that Councillor Elston is a dairy farmer, and he gets his milk processed there. And if this expands, that's going to be good for him. So even though it's only a very small, he's not going to really benefit financially. It won't make a big difference to him, but that's enough. So I said, I think you have got a pecuniary interest, and I don't think you're saved by this small one, because I think most people would say, no, I'm not sure you're going to vote just because it's the best thing for the people. I was absolutely certain that person was not influenced by his share, but that's not really the point. It's what people might think. So my advice was, I think you should, excuse yourself from that. So there is a whole list, if you're a farmer and it's something to do with the Drainage Act and it's going to affect your property, you're still allowed to vote on it. So I could send along just, the actual excerpt from section 4, or maybe Chris has something she could show you. The act isn't really very long. It's just some definitions, and definition of the indirect pecuniary interest, definition of a deemed one, list of exceptions, and then the rules, don't vote kind of thing. So anyways, that's I think this is why I get a lot of calls for advice on municipal conflict of interest stuff, because you have to kind of work your way through it, and it can seem a little bit, it's not intuitive necessarily. So there's some timelines here. They don't want these things sort of lingering. So, if you're going to go to me or to a judge, you got to do it within 6 weeks. of the person becoming aware. So it's when somebody becomes aware that maybe you had a conflict and you voted, or you had a pecuniary interest and you voted. They have 6 weeks to either go to a judge or come to me. And after 6 years, it's, too late. So, and I have to do my report within 180 days of getting the application, which seems like a long time, but, it goes by pretty quickly. So I think there is a real, the province has said, this is important. We don't want these things lingering. If there's a conflict or an inquiry into a conflict, it should happen fast. So probably good things to have in there. So I put this in just, remember I said that to start back in, I'll say the old days, the Municipal Conflict of Interest Act was applied by a judge. So if a member of the public or a fellow councillor thought that a councillor had a pecuniary interest and shouldn't have voted on something, you had to go, pardon me, you had to go to a judge. And so that's an onerous task. It's an expensive task. And back then, the judge, if the judge found that you had a pecuniary interest and you had voted, he didn't have any choice but had to vacate your seat. So you got into situations where something that maybe it was inadvertent, maybe it was a completely benign, matter that the member, did in fact have a pecuniary interest and voted. And if someone went to a judge, the judge has to vacate their seat. So what ended up happening was judges, I think, are reluctant to sort of negate an election, someone who's been democratically elected. You don't want to take away their seat. So they would find all kinds of ways to say, well, I don't think there was a conflict there, or for whatever reason, not to vacate the seat. And some of the reasons the judges have given have been built back into the act and recognized as being a pretty good reason and why somebody shouldn't be punished. But so you still can, someone can come to me and complain, but they don't have to, they can go to a judge, because the judge still can vacate your seat and ban you from running again for up to 7 years. So, and I guess the idea is, if someone has a very serious conflict of interest, say they are, a shareholder in a numbered company that owns part of another numbered company that owns the land where the rezoning happened and they stand to make millions, it's not much consolation if I write a report and say they should be reprimanded or even docked their pay for 90 days. So, it's to deal with situations where it's, serious conflict that you can go straight to a judge, or if I get a complaint and I start working my way through it and I think, oh my God, this is serious, then I can go to a judge. And so it's really just a way of, sort of a higher power than me having the ability to impose a much greater sort of sanction. So it's interesting because the requirement on me, if I get a complaint under the Conflict of Interest Act, I have to say, I'm not bumping this up to a judge, and here's why. And so I look at, some of the things that a judge would look at when they're looking at it, so you'll see there 1, 2, 3, did the person take reasonable measures to prevent the contravention? Did they disclose the pecuniary interest to an integrity commissioner in a request for advice and acted in accordance with the advice? So this is why if you get a letter from me saying you don't have a conflict, or you don't have a pecuniary interest, it's a good idea to keep it, because if somebody doesn't accept, that you did not have a pecuniary interest, and they go to a judge, and a judge says, well, it's nice, that your integrity commissioner said you don't have a pecuniary interest, but I think you do. But so the judge can take that letter, and it may make the difference between having your seat vacated and the judge maybe ordering you to pay the money back, or reprimanding you, or the judge docking your pay, because they can do all kinds of things too. So that's why it's important, if you get advice from an integrity commissioner, keep it, because it's not a complete answer or defense. You could still be found to be have had a pecuniary interest and breached the act, but it sort of goes to the sentencing. So it may relieve you from having your seat taken away if, you in good faith, you went and you got advice and it just happened to be not the right advice, but still. So good reason to keep hold of letters from integrity commissioners on these kind of things. And I think that's all I had. As in terms of prepared remarks, but I'm happy to stay with you and open, or go into close and answer any questions that you might have. Thank you.
Thank you. I never know what, as Mr. Elston has pointed out, we may sometimes use a name of an unidentifiable individual, or, questions like that. So my thought is, if we have questions for him now, is it best that we go into closed session in case you say, this guy threatened me, is he an identifiable individual? Because around here, everybody's an identifiable individual as far as I'm concerned. So are we better to go into closed session if we have questions? Like I had one, council determines future pay raises for council, but he's already pointed out that that's part of our job to do that. Every time I go to do that, I feel guilty that I'm determining my own pay, but it's legal and nobody else would do it, because if you ask the town people themselves, who never get a pay raise, would be paying them. So that is a question that I know I could ask in, but I wonder if we have other questions, if we want to go to private session and then just go on with our training after that. And the rest of the training will be private because it's all closed session, whatever. So what does council think? Closed? Or I have questions about when we have minor variances, if we're the people that we're not in it, but what if it's my daughter that wants a minor variance? Is that a conflict of interest? Not necessarily pecuniary, but I would suggest it would look like a conflict of interest, and I don't know the answer. So, pardon?
Closed session.
Okay, so we'll move to closed session. Okay.
Okay.
So in this case, I need a mover and a seconder, Councillor Yam and Councillor Butler. And then I'll read the motion and ask for a vote. It's number R 2022-206, moved by Councillor Yam, seconded by Councillor Butler, that this part of our meeting will be closed to the public as authorized by Section 239, Section 3.1 of the Municipal Act 2001 C-25 for consideration of the following subject matter: educational or training sessions. Meeting of a council may be closed to the public if the following conditions are both satisfied. 1, the meeting is held for the purpose of education or training the members. 2, at the meeting, no member discusses or otherwise deals with any matter in a way that materially advances the business or decision-making of the council. Purpose of this closed session, council training for the purposes of orientation to the municipal procedures on the start of the new council term. I'll call for a vote. All in favor? Carried. Unanimous. And it is, so we'll go to closed session at 5:40 PM. Thank you. So
One second, your worship, I just need to